Yes, good evening to everybody. Welcome to the today class of the Law Start, the remedial coaching for those who are going to sit for the 27th September 2021 examinations. Yes, please read what I share the screen on the screen, please.
Okay, sir. Happy Engineers Day.
Go on.
The birth anniversary of Sir Mokshagundam Vishweshwaraya is celebrated as the Engineers Day on 15th September 2021. He is also known as the father of Indian engineering because of his enormous contribution and innovations in the field of engineering and the development of the society.
Very
That's a
good,
Dr.
very
Mohammed
good.
Saheb. Okay, sir.
Then my name is there. Now I told you that I am going to deal today the general defenses in chart, because generally it may be asked in the long questions or it may be asked in the short answer questions also. So generally that we will have the 10, but we will concentrate on only the 8 because sometimes we will use the triflings, trifling, triflings, though it is a defense, but generally that we don't take it because nobody would go for the triflings to the court of law. It is like that for the cooking for a quarter anna chicken, then 3/4 of the masala should be needed or spices should be needed. So that was the thing would be there. That's why we will concentrate on only the 8. Number 1, warrant did not fit injuria. That is the defense of the consent. We can say the free consent also. Number 2, the plaintiff, the wrongdoer. Number 3, inevitable accident. Yes, you read the number 4.
Acts of God or vis major.
Very good.
Fifth, private defense, mistake, necessity, and statutory authority.
Yes, the right one is the statutory authority. So now
Okay,
let
sir.
us concentrate on the one is not fit injuria. That is the free consent, or we can say defense of the consent. So here what we want to see is, before I could go further, see a person who has given the consent to do, undergo any injury or any harm or any other thing is concerned, or the same person could not say that, no, you injured me and hence you have to pay the compensation to me. Generally that it is going to happen whenever you go to the doctor, and if the surgery is needed over there, and the doctor will take the consent of the patient. If the patient is unconscious, doctor will take the consent of whom?
The responsibility.
A responsible person. Suppose the wife is there, the husband's signature. If the children are there, then the father, mother signatures. So they will take it. It gives the consent that, of course, they do the surgery. Of course, if they follow all the precautions over there, but still a patient died, at that instance, it is not in their hands because they say that you are given the consent. For instance, you take the a boxing. You might have seen the boxing. And in the
Yes.
boxing, the people will be bruised, and sometimes they will be bleeding also. Of course,
Yes.
they use the what I say, a helmet type of the thing, pads, the head pads and other things also. But instead of that also, that you are given the consent for the sports. If you get an injury, would be there, which is a legalized one, not a not illegal way of the beating. So the ball is somewhere and you are beating directly to the ankle of a person or the leg of a person, then you can say that it's a voluntary not fit injury. So let us see that the very first defense that comes under the general defenses in torts lies the voluntary not fit injury, which is also known as a defense for the consent. And so here are the notes of the voluntary for not fit injury with all the reading cases. Of course, there are because whenever that law of tort is there, you cannot give the one example and one of the example, no examples will not be there. Of course, examples we can give it, but still it needs the case law, decided case law, which is a must, and where you have to say whether the voluntary not fit injury is applicable or it is not applicable. So that way that we can make it out. So let us see that whenever you give a consent of a particular thing, at that instance you cannot again file a case for the injury if you caused over there. So no man can enforce the right which he has voluntarily. Say I said voluntarily. So that is very much important. Voluntary waived off or abandoned consent to suffer the harm may be expressed or implied. In both the way it will be there. Now let us see the a remarkable English case law that says the Hall versus Brooklands Auto Racing Club. This is a case law where we can say the spectators, the plaintiff, during a car race got injured due to the collision of the two cars. So if the spectator, because of the collision of the two cars, one of the car reached to him, of course, very near to him, and injured the spectator. During the collision, one car came into the stands, which caused injury to the plaintiff. and plaintiff sued the defendant for the damages. There is a compensation, but the defendant was not held liable as the plaintiff himself took the risk of injury. For instance, if you are watching or viewing a live cricket match, suppose the ball comes to the arena of the where the spectator sat over there and injured it. Can at that instance could you file a case against the board or the person those who are responsible for the conducting the such as sports in that arena? Yes, tell me.
No, no, we cannot, sir.
The reason is voluntarily that you are because always the ball will not reach to the spectators every time. Only once or two occasions you will come over there. But naturally, that the person that who look at the ball, they will come aside automatically. So at that instance, you will not hurt it. Suppose if you are a good catcher, let me presume it. The spectator is a good catcher, he will catch the ball. What do you say?
Yes. Yes,
So
yes, sir.
at that time, you can use the maxim. There is voluntary not fit to injury. The maxim can be used over there at that instance. So that is a very important factor, and that is one of the case law, sir. Because I can cite the case law, sir. Okay, what is the case law that you are going, sir? Sir, Ellamma versus Pullaya. Did you see that such a case law is there?
No.
You cannot make a fool to examiner. Please note the point.
Okay.
So better you cite those case laws, those who are there, because the examiners reads well and he will cite the case laws, even including the latest case law. If you say it's the latest case law also, he will refer the latest case law. He will say, this man wants to fool me. So naturally, that will disgust the examiner. The examiner will disgust you by lessening the marks in one way, in another way. So let us go to the another case law. That is the first case law. That is the Hall versus Brooklands Auto Racing Club case law, where the collision of the car hit the spectator. The spectator could not get any compensation, and that is the reason the case law is applicable over that defense of voluntary not fit injury is applicable over here. So that is the number one. Then yes, it's the case law is there definitely. Padmavati versus Duganaka case law it is there. Yeah, here the case law is goes in this way. The plaintiff jeep driver, along with the two strangers in the jeep, was traveling, and the bolts of the tires of the jeep opened up, due to which a car toppled. So sometimes it will happen. The wheels comes out of its axle because of the various other factors are concerned. At that instance, we can say it is an incident. So one stranger was thrown out of the jeep, and while the other stranger was severely injured, since it is the sheer case of the accident, the defendant was not liable. Moreover, when you take the lift, if a lift taking the stranger, if a stranger takes the lift at that instance, he will not get anything because you are taking the lift on his own risk. That is the word where the Padmavati versus Duganaka case law says the voluntary not fit injury. Number one. Number two, we can change the sheer accident also. So that is the one thing. So whenever you take the lift, you will not get any compensation. Or when you travel in a lorry, also you will not get the compensation. When you travel in the auto, also you will not get the compensation. Of course, the limited members should be there. And moreover, the auto, you should have the permission to go from the far distance also. Suppose if it is the own auto, he can make it out. Suppose something goes wrong over there, they will include only 4 plus 1, 5. If any other person would be there, it's illegal to take that much people in the auto. Do you agree?
Yes,
So
sir.
yes, sir.
Yes, sir.
Yes. Then can you read the another case that the Wood Bridge versus Summer? Sumner? Anyone? Anyone? Unmute and read.
Plaintiff was a photographer in the horse race.
Good.
While he was clicking photographs during the event was being conducted, he was
Okay.
severely injured by the defendant horse. The
Good.
defendant was not held liable to the plaintiff himself, consented and voluntarily came here to click the photographs.
Yes. Whenever the photographs would be there, in the horse race, they will go very close to it and they will take the photographs. And at that instance, you are taking on its own risk. Because when you want to take the photograph, you can use the zoom lens, and with the safe side that you can also take the photograph as if that you are in front of the horse. In that way, you can make it out because this voluntary not fit injury will be applicable over there. At that instance, if he is got injured by the horse, and at that instant the photographer will not get any compensation. Yes, whether the non-fit, that is voluntary not fit injury is applicable over here or not applicable over here. Yes.
Applicable, sir.
Applicable
Here
only.
is the applicable, sir.
Yes, that is the point. Next case law, Illat versus Wilkes is another case law. A plaintiff stepped into the land of the defendants knowingly that there were spring guns set up. Because sometimes the people will keep the spring guns so that the animals will not come and spoil the total field. So at that instance, the spring guns, if he got injured over there, because he is having the such a knowledge and knowing the same, plaintiff entered and he was hit by a spring gun, and since the plaintiff was well versed with the presence of the spring guns, and he cannot recover the damages from the defendant. Suppose if the plaintiff could not have the aware of it, then at the time what will happen? So he has to prove it, whether he is aware of it, we are not aware. Generally, whenever the spring guns are kept over there, they will keep a caution board. Spring guns are, be aware of it. Like the caution board you will see in the houses of the people. What caution board you could see in the houses of the people? Yes, anyone?
Dogs. Beware of dogs.
Yes, the beware of
Be-
dogs, such a signboard would you could see it. Sir, that is the language in a different terminal, that the language which is not known to us. No. Generally, the people use such language which will be known to the people in that place. Suppose if it is, say, Telangana, Telugu would be there. If it is, of course, if you take the Andhra Pradesh also, it is the Telugu would be there. But if you write the same Telugu in the Punjab, and that fellows will not be there. But anyway, in addition to the writing, they will use also photographs. Which photograph they will keep it over there?
Dog photograph.
Obviously,
Yes.
it's a dog photograph. They will keep it over there so that that gives the consent, because a sign also speaks. Even if you keep a dog photograph also, it is not for the selling purpose. It is for the caution purpose they are making over there to say that be aware of the dogs. Is it not? So here also, that knowingly that the spring guns are over there, and if he entered over at that instance, if he got injured by the spring guns, then the voluntary not fit injury will be applicable to the defendant. Defendant will take the defense of the voluntary not fit injury. Okay. Okay, let us see the another case la Lakshmi Rajan versus Malar Hospital Limited. And in this case, plaintiff was married woman of 40 years who got lumps in her breast. In her breast, there are lumps are there. The Malar Hospital has taken the consent of any mishappening during the surgery. They will take the consent of the people those who are related to the patient during the surgery. Yes, you are speaking. I could hear your voice. Please unmute it. అయ్య గారు మీరు ప్రైవేట్ మాట్లాడింది నాకు వినబడుతుంది సో యూ కెన్ మ్యూట్ ఇట్ దెన్ యూ కెన్ స్పీక్ ఓకే కమ్ టు ద పాయింట్ డ్యూరింగ్ ద సర్జరీ అలాంగ్ విత్ ద బ్రీస్ట్ లంప్స్ అండ్ హర్ యూటరస్ ఆల్సో రిమూవ్డ్ వితౌట్ ఎనీ జస్టిఫికేషన్ సి వేర్ ఈస్ ద బ్రీస్ట్ వేర్ ఈస్ ద యూటరస్ it's very 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 distant. The breast is somewhere and the uterus is somewhere, but here they are removed the lumps from the breast, but in the simultaneously they are removed the uterus also without any justification. And since the hospital has taken the consent only for the lumps, that is the breast lumps, they want to remove it, but they have removed the uterus at that instance. For the removal of the uterus, the patient did not give the consent. At that instance, the hospital is, yes, liable.
Liable.
Yes.
Yes, liable. Of course, there is some small case laws also there where you can say whether the consent is taken or not. Here, the immoral, that is from an immoral cause, no action arises. Suppose there is a agreement between the two thieves. Whatever you rob it, we will share half of 50-50. So they put it in writing also. Could they go to the court of law to share the 50% they looted? Yes.
No.
Answer is no.
It is not legal.
It is not legal. It is an immoral act. You see, here is also same another immoral act. It is a triple X case law. Yeah. It is a triple X case law, R versus William. Actually, in this case law, the defendant is singer who has to teach the students about the singing. That is, he is making the thing. The defendant during the singing lesson convinced a 16 years old the students, the young student, the lady student, the girl student, to give her consent for a sexual intercourse. That we can say BBC. Suppose if you do the BBC, your voice will be very smooth and very nice and very sweet. But this poor lady, she doesn't know what is the connection between the BBC and the tone, and she thought the same. Then she gave the consent. But such a obtaining the consent is amount to obtaining the consent is a fraud, and we can say it is not a free consent, then voluntary not fit to injure is not applicable over there. Are you following me?
Yes, sir.
Yes, sir.
Following you,
Sir.
sir.
Yes. So that is the case law R versus William, and the R versus Clarence also another case law where the consent we should not get it by the fraud or by the any other what I say influence also. So here the R versus Clarence, the defendant has a sexual intercourse, that is the BBC, which his wife knowing that he is suffering from the sexually
Compensation.
transmitted disease. Yes, sir.
Compensation.
Yeah. See, definitely the teacher would be held liable for the rape. Not only the victim should be compensated, he will be put beyond the bar. Is it clear?
Yes, sir.
Very good. So R versus Clarence, here they also case law, and the husband knowing that he is suffering from certain diseases like gonorrhea and AIDS and syphilis, and transmit the disease to the wife. Husband doing so, where the husband was not liable for any kind of damages. So now the question comes over. If the wife and husband is there, at that instance, the husband need not to say what that he is having. But it is one of the ground for the taking the divorce. Are you following me?
Yes, sir.
But whether he transmitted such a sexually transmitted disease to a prostitute, now you tell me.
It is also
Whether the
not like,
prostitution is allowed in India.
no, it is not legal.
It's not allowed over in India. In some other countries may be allowed, but here it is not allowed. If you have the extramarital relations, okay, it is not amount to the prostitution as per the new directions of the decision of the Supreme Court, but it is becomes a ground for the taking the divorce by any one of the spouse. Okay?
Okay, sir.
Of course, wherever the consent is taken by compulsion, wherever the consent is taken by the fraud, wherever the consent is taken by the undue influence, that is not amount to free consent. Is it clear?
Okay, sir.
Yes. Now the question comes over there. Suppose the plaintiff knows there is a danger, but still the people will work. For instance, you take the Singularity College Company Limited. They know they will be underground, they have to go down. If any other roof will falls down, they will become a papad. But still they do work it. Does it mean that it's a voluntary not fit injury? They give the free consent? Answer, no.
No.
They know the risk. Yes, no doubt they know. But still, they agree to do the work because for their livelihood. It doesn't mean that they have given the free consent. Suppose somebody died in the underground, that's the mine, underground I am speaking about. He will be definitely will be compensated, even though he has given the consent to work under such a dangerous situation because of his livelihood. Because of his
Livelihood.
livelihood, he will give the consent. But it doesn't mean that it is a consent given. So the same thing is happening in the Smith versus Baker. Here the Smith versus Baker, plaintiff a woman, the workman, employed with the baker to work on the drilling for cutting the rocks, stones, quarries. So the quarry is from one stage to another stage, they are carrying by the bulldozer, the big the boulders will carrying from one place to another place through the crane. If any boulder will fell down from there, even though they have taken the taken the precaution, but still if it falls down and got the injury to the employees, those who are working there, at that instance, they will definitely will be compensated, and the defendant could not take the defense of the voluntary not fit injury. Is it clear?
Okay, sir.
Yes.
Sir.
In the Imperial Chemical Industry versus Shotwell, sir, case la pair Rayal na sir, Rayal. Yes, you are supposed to write. Sir, can we write the both the parties' name? Yes, if you know the both the parties' name, you write the both the parties' name. Suppose if you know the only one party name, especially I should have to remember the first party name. That is the Imperial Chemical Industry case law, you can write in that way. But very seldom the people say Shotwell case law. No. First you read the first one, later you can think about the second one, but you cannot mention the second one. But still, some of the examiners say, okay, at least you remember the second name of the case law, better we will make it. So better to keep the memory or sharpness, because no case law, no tort law. No case law, no tort law. No cases, no marks. So Imperial Chemical Industry versus Shotwell is also another case law where the George and James were working in the defendant's quarry and testing some of the detonators, that is like bombs, without requisite precautions, even after the employees' warning, and resulted in the explosion. On the both the George and the James got injured. The defendant was not held liable. Why he is not held liable? Can anybody will tell me?
Not taking the precautions of the workers, sir. So that's why the company is not pay the amount, sir. So the defendant is not in a liable, sir.
Yes, when you're testing the detonators, you cannot test like a potatoes you are testing, because they are the separate aprons, separate gadgets. Through that, there is a helmet, there is a what is a bulletproof glasses, and many other things would be there. When those you supplied it in such a way, when you could not wear it and you test it without wearing it, if you got it injured over there at the time, the defendant is not liable. It is purely your negligence. Is it clear?
Yes, sir.
Sir.
Okay, next case law that we'll say Dan versus Hamilton. This is another case law. A plaintiff lady, knowing that the driver was drunken, and asked the driver for the lift. Actually, it is not a lift; it is for the hire. Okay, due to the drunken driver's negligence, car crashed in which the driver died and the plaintiff was injured. Can the plaintiff will get the compensation? Answer is, even though there is a contributory negligence was there, but still the plaintiff will get the compensation. The reason is, if a person sitting in the taxi, the presumption is that he is fit enough to drive the car. Is it not? Yes.
Yes, sir.
We cannot test each and every day. Okay, open your mouth. Okay, you say exhale. Let me check whether you are drunken or not. After checking only that you will hire the taxi.
No.
No, because the presumption is that he is fit enough to drive it. That is the presumption. So Dan versus Hamilton is not amount to the consent given over there, even though she knows that the driver is drunk. So another case is Morris versus Murray. This is the case also the same, because in this case what happened? The plaintiff had been consuming alcohol for several hours with a friend. Both are fully drunken. Later on, at the end of the evening, the plaintiff drove the friend to an airfield, and they have make a joyride with a light aircraft. So the flight ended in a disaster, and the pilot died, and the plaintiff was injured. And the plaintiff sued the deceased pilot's estate, and the plea of the warranty was raised against him. And at that time, now you tell me whether he will get the compensation or not. Both are drunken, pilot and the person who is flying like a passenger. Tell me.
No, sir.
Answer is, by intoxication,
Full
you are
knowledge.
not supposed to fly. You are not supposed to ride also even a bicycle.
Yes.
Even a bicycle also. Because it is not in your control.
Sir,
So that is the reason both are at the
Sir.
wrong. Yes.
sir,
Yeah.
Ramesh Bhadrachalam.
Yes. So though you want to say that you are present. Okay, I appreciate. Here I can see that who are the present over there because they joined with that names. But some of them, yes, M. Ramesh and Yarani, Karthik, and C.S. Pushpalata
Sir.
were present over there. Yes, I could see the names over here. Okay. Now let us come to back to our studies. Now, on Pitts versus Hunt is another case law, and where also the same thing happened. That the warranty is not applicable over here because both are drunken. The rider who is riding the motorcycle and the person who sat behind the back seat is called. Tell me anyone.
Sir.
Yes. The person who is riding the motorbike is called rider. The person who sat behind the rider is called. If you know, you tell me yes. If you don't know, you say pass on. I will give the
Sir,
answer.
pass on, sir.
Pillion rider.
Pillion.
Pillion. Pillion rider.
Indian Raider.
Yes. If both of them are drunken over there, if one of them got injured, the another one cannot claim the compensation. The reason is, after drinking, you are not supposed to ride the motorbike. So this voluntary not fit injury are not at all come into the picture because first itself you are illegal act that you did it. Is it clear?
Illegal act.
Yes. See, even if a rider is keeping the helmet, now yesterday that I paid the fine 100 rupees because my pillion rider doesn't have the helmet. He said, the pillion rider should also have the helmet. In Hyderabad, I'm speaking. I don't know what is the position in the Bhadrachalam and Khammam and Kottagudam and other area is concerned. Both should have to wear the helmet. If
Helmet.
any one of them not there, 100 rupees. Thank God, only 100 rupees that I paid it.
100 rupees fine, sir.
Yes, fine.
Yes.
Yeah. So both of them you should have to wear the helmet. That's later another case like we can see that Slater versus Clay Cross Company Limited. The plaintiff was hit and injured by a train driver, and while she was walking along the narrow tunnel on a railway track, which was owned by the defendant company. And the defendant company knew that the tunnel is used by the trespassers. And driver must have slowed down the train and must have whistled. An accident happened due to the driver's negligence, so the defendant was held liable. Even the defendant knows it that people are using the tunnel because of a shortcut. At the time, whenever the train passes through the tunnel, number one, he should be slow. Number two, yes.
Sir.
It should be cautionary.
No, that is a cautious word. That is called slow. Number two,
Whistled.
whistle. You have to blow the whistle. Is it clear?
And horn.
Horn. I didn't say horn or say whistle or whatever. Or you say siren. But a sound should be produced over there. That's the main idea. Of course, there are certain exceptions are there. Rescue cases exceptions is there. Like Hines versus Harwood case law is an exception because the defendant servants left two horses unattended in the street. A boy thrown a stone toward the horse, and a horse bolted and started running here and there. And the horse came very high speed, and it ran over by the child and the mother. And meanwhile, a person saw it. Of course, they hear the policeman, and he rescued it to stop the horse. When he was stabbing the horse, that he got injured over there, but still voluntarily he did it. But still, in the rescue cases, voluntary not fitting injury is not applicable. Even though he has given the consent to stop the horse, while you are doing so, he got injured. But still, you will be compensated. So that is the reason in the rescue cases where the imminence of danger is there. If anybody stopped it, meanwhile that he got injured, at that instance, he will be entitled to get the compensation. So that is one of the case law, that is Hines versus Harwood. There is a remarkable case law will come, and where the plaintiff will get the compensation. In the same manner, can we read the Wagner versus International Railway? Anyone?
Wagner versus International Railways. Railway. Sir, railway passengers was thrown out of a running car by a sudden
Lurch.
lurch, sir. Lurch, lurch.
Yeah, lurch.
When the car, okay, sir. When the car stopped, rescue got down to find his cousin's body. Due to darkness, he also got injured.
Yes, at that instance, suppose the passengers has thrown out of a running car by sudden lurch. Suppose somebody is thrown out of his speed car when you apply the sudden brakes, when because of the lurch jerk that somebody fell down over there, to know whether that person is there or not, he wants to rescue it. Meanwhile, because of the darkness, he got injured over there. But still, it's the rescue cases. If the person got injured, at that instance, he will be entitled to get the compensation. In the same manner, Unfair Contract Terms Act is there. In the Unfair Contract Terms Act, we cannot make a fraud type of the slogans. If you use this pen, you will get the A grade, or you will get the 70% marks. Can you sell this such a way by making the fools to the customers? This untrade fair practice would be there. At that instance, yes, voluntary not fit to injury is not applicable over there because he purchased it thinking that he is going to get the 80% marks in the examination. Because such a thing will not be happen. If such a miracle pen would be there, everybody would have to buy the pen and write the examination. What do you say? So unfair contract terms also at the time this voluntary not fit injury is not applicable. So that's why you can make it out. This is only the first defense that we make it out. Then the second defense is plaintiff the wrongdoer. So the second defense that comes under the general defense is the plaintiff the wrongdoer. So here notes the plaintiff the wrongdoer means in the leading cases when you yourself also a wrongdoer at that instance, you cannot go to the court asking for the justification because you yourself is wrong in your own way. So in that way, we can also use the maxim X should be causa non aritor actio. From an immoral cause, no action arises. So, like I given an example of two thieves, they made the robbery and got a lot of money and jewelry, and they made an agreement that 50-50. And the person doesn't want to give the 50 because he took a lot of risk and he say, I will give you only 30%, 70%. So no one can go to the court of law for their division of the booty because both of them did a illegal act and immoral act at that instance. So you cannot go to the court. The person who go to the court should go with the clean hands. That is the principle of that is another way theory of equity. You will say that is equity principles we can say. So let us see the Bird versus Holbrook case law. In this bird, the defendant set a spring gun strap in his garden to protect his property. So he put his spring guns in the property to protect the property from animals as well as the trespassers. And the spring gun trap injured the Holbrook. Plaintiff innocent, trespasser is, and plaintiff sued the defendant and the claim for the damages, and the defendant was held liable. Why defendant is held liable? The reason is, whenever you keep anything in a dangerous, you have to keep a caution board. Spring guns, beware of. Suppose some people, I don't know whether you saw it or not, they will keep the live electric wire over the fencing, over the boundary. Did you see such a thing?
Yeah, I saw, sir.
But there should be a caution board. Live
Yes, sir.
electric wire, 220
Oh, to
kV
the
or so this much kV. Live electric wire, they will keep the caution board. Or they will keep a signboard also. What is the signboard? One skull and two crossed bones. One skull and two crossed bones. What it depicts? What it shows? Danger. It shows danger or danger. Okay, you say
danger, sir.
the way you want, but the spelling is DANGER. Is it correct?
Yes, sir.
Okay, let us go to the third inevitable accident. And here the third defense comes under the general defense is inevitable accident. And here the notes of the inevitable accident. He tried to save it, but he could not save it. And that's such an accident is called inevitable accident. But not negligently or intentionally. If he does so, then naturally we cannot say inevitable accident. Suppose if we are going with slow speed in the school zone, but he applied the brakes, but there is a wet road is there. At the time, if it is skidded, and at last he got a light injury at the behind portion, the rear portion of the motorbike, and at that instance, we can say it is an inevitable accident. Let us see one of the leading case law is Stanley versus Powell case law. Can anybody would unmute and read Stanley versus Powell?
Sir, Stanley versus Powell, plaintiff and the defendants were members of a shooting party. Defendant was focusing on a peasant. One OS, his pilot from his gun hit the branches of the tree that changed its direction and accidentally wounded the plaintiff. Since it was a sheer case of accident and was not forcible, defendant was held liable.
Not held liable.
Yes, sir.
There are two shooting parties. They went for the shooting in the forest. One shooting party at the opposite direction, another, both are in the opposite direction. So one will shoot at the bird, the pheasant, but the pellet which came from his gun, it touched the oak tree and glanced off and hit the opposite side, the party, and who was also for the shooting. So naturally here, it is only a sheer accident when the pellet will hit the oak tree branch and took the reflection to the different direction and hit the plaintiff. At that instance, we can say it is not a accident, it is said to be the immutable accident. Because we cannot foresee such a thing where the pellet glanced off and injured the another hunting party, that is the plaintiff. So that is the case law. The next case law is Sridhara Tiwari versus UP State Road Transport Corporation, that is called SRTC, where the bus of the UP, that is Uttar Pradesh, SRTC, that is means State Road Transport Corporation, was passing through the village and suddenly a cyclist came on the road. To save him, the bus driver applied the brakes, but due to the wet road, on applying the brakes, the bus slipped and skidded and collided with another bus coming from the opposite direction. At that instance, the defendant was not held liable as it was a sheer case of accident, because in the village area the bus speed is very much less, and all of a sudden the boy has come and he's applied the brake and he's far to the right, but because of the wet road it skidded and hit the opposite direction bus. At that instance we can say it is a sheer accident. Now let us see the another case law, Brown versus Kendall case law. The plaintiffs and the defendants' dogs were fighting. There is a saying is there. I don't know how far that people. When you are cutting the wood, you should not go near. When somebody is beating the wife, you should not go between them. And in the same manner, when the dogs are fighting, you should not go near to it, because the two dogs will bite you. So here, the defendant dogs were fighting. The defendants thrown a stone in attempt to separate them, but the stone accidentally hit the plaintiff standing nearby, and it's a case of the accident, and the whole incident was not foreseen, and therefore defendant was not held liable. So naturally, when such a thing would be there, one cannot foresee that. Suppose the intention of throwing the stone is to separate these dogs, or we can also say, suppose if he is using the stick and to separate the dog, for instance, the stick hits somebody's eyes and where he lost the eye, at that instance also it is said to be the sheer accident, and one cannot get any other compensation for that, because it is purely the immutable accident. In the same manner that what we read it, giving the lift to the strangers, that is the Padmavati versus Duganayaka. The jeep driver case also there. The bolts come out from the rim, and where the wheels come out. At that instance, the jeep becomes topsy-turvy. At that instance, if the persons those who are traveling are also injured, or the persons who are near to that also injured over there, generally that we will take the defense of the sheer accident, that is inevitable accident, and where the defendant was not held liable. Yes. Can anyone read what is the fourth one? Yes. The fourth defense.
The fourth
Anyone
one,
can unmute and
act of
read.
God. Sir, act of God versus major. The fourth defenses that comes under the general defenses in torts law is act of God. So here are the notes for act of God with all the leading cases. Extraordinary
Occurrence of.
occurrence of circumstances which could have not been foreseen and guarded against, or more accurately, due to natural cause, directly or exclusively, without human intervention, are two
Good.
essentials of act of God. One, there must be working of natural forces. Two, occurrence must be extraordinary and not one which could have been guarded against.
Yes. These are the two essential conditions should be fulfilled over there. One is it is a natural force, and that occurrence is in such a way, it is an extraordinary way, and could have been guarded against it. Then, what about the pandemic? Is it the act of God? Yes.
తెలంగాణ
Circumstances. Sir, somebody talking, sir.
Yeah, they are speaking each other, keeping up the thing. Please,
Circumstances of weather, sir, or pandemic, act of God means
yeah, pandemic
tsunami.
is not a act
Tsunami,
of
sir.
God, it's the act of man. But hurricane, cyclone, tsunami,
Yes, sir.
earthquake, volcanoes, these are all said to be the act of God, which is not in the control of a human being. These are natural disasters. But if the rains are concerns, if the extraordinary rain is there, the rains of the 15 inches, oh, it's a heavy rain. We cannot imagine. Because 7 inches or 8 inches rain should be the
Damages,
heavy
sir.
rains. Yes?
Damages,
No.
sir.
Yeah, damages are not. The only the thing is there when the volcanoes are there, earthquakes comes, tsunami comes, damages are there. Only the central government as well as the state government should have to come to the rescue of the people.
Okay, sir.
Suppose if it is insured over there, at that instance, if the wording is there, it's the act of God also, the insurance company would be held liable. If it is given in the contract papers, at that instance, insurance company would pay the compensation.
Insurance, corporate companies.
Yes. So in the Nichols versus Marshland, the defendant created an artificial lake on his land by damming some of the natural streams, and due to the extraordinary rainfall, such water washed away in the plaintiff bridges. Even it was said that the rainfall was the heaviest at the time till the time, since it was not an act of God, it is an act of God. Defendant could not guard that he was not held liable. Suppose extraordinary rains are there in these days also, where even the cars are washed away, even the bridges are washed away, roads are washed away, and the anicards are gave the bridge, and the houses are filled, and many houses are even floating on the water. At that instance, we cannot say nobody would get it. It's an act of God. Only the government will come to the rescue of the victims. So the extraordinary rains are there. At that instance, we can say it is an act of God that is observed in the Nichols versus Marshland. And Kallulal versus Hemachan, if the rainy season rains are common, if the common rain season, if there is a roof leakage is there, from the leakage, a mud wall is got wet, and the mud wall fell down in the night where the children are sleeping over there, when the children are buried in the wet wall, the gravel, at that instance, we cannot say it's the act of God because it's the act of human being. The reason is you have not repaired the leakages of the roof. Is it clear?
Yes, sir.
Is it clear?
Yes, sir. Clear, sir.
When you are negligent over there, we cannot say it's the act of God. When you are not negligent, which is not in your hand, which is extraordinary, and at that instance, we can say act of God. Next, fifth and private defense. Private defense, what will happen? Suppose somebody slapped you. Slap ante తెలుసా అండి? You know what is meaning
తెలుసు
of
సార్.
slap? What is that?
చెంప మీద కొట్టడం సార్.
అదే మళ్ళీ బటక్స్ మీద కొట్టడాన్ని ఏమంటారండి? With the open hand, beating on the back, buttocks. Spank అంటారు. SPANK, spank.
ఓకే సార్.
SPANK, spank. గిల్లడాన్ని pinching అంటారు.
పించింగ్ సార్.
Can you pinch anybody? Yes.
In childhood, sir.
It is a private defense. Okay, suppose if he pinched you, okay, you can make 2 pinches. One is capital, another is interest. So the private defense is concerned. Suppose use the same amount of the force, not the bigger force. Same amount of the force you have to use it. Suppose somebody slapped you, can you take out the revolver and shoot at him?
No, sir.
The same use of the force you are use it. Suppose if he slapped you, you can use 2 slaps. One is capital, another is interest. Just now I told you. So you have to use the private defense the same amount of the force, but not the extraordinary force you have to use it. Of course, the 5 minutes would be there left over there. After 5 minutes that I will continue it. Meanwhile, it will be disappear. Then we'll stop it. Or can we stop it? Because 5 minutes still we can complete this 5th one. The Bird versus Hallbrook case law, that is the Bird defendant spring guns case law. where the traps are put it over there. Suppose excessive force are used over there, you have to keep the caution board. The spring guns that use excessive force is a dangerous thing, and at that instance you have to keep the caution board. Otherwise, your force is more than what is required over there. So the defendant was held liable here, because no doubt it is a private defense, but you have to keep the caution board. In the same way, Ramanaju Mudali versus M. Gangan. The defendant laid some live wires around his house. Plaintiff trespasser received the shock due to those live wires and was severely injured since there was no warning given. Defendant was held liable, because there should be a warning board or a sign board or a caution board to say that live electric wire would be there. Be aware of it. In the same manner, Cornell versus Renison, the plaintiff went up a ladder for nailing a board in the wall, and if you just threw the ladder at that instance, because the trespasser to keep the ladder on his wall, but still it is said to be the amount of the force you used it from there, you fell down and got injured. At that instance, naturally, that a person would be liable. Plaintiff sued the defendant for assault, and defendant was held liable. And the Creswell versus Searle also, this is one of the case law. The defendant shot the plaintiff's dog, which was chasing the herd of the sheep, and keeping in the mind the dog was actually tracking the herd, and when it was shot down by the defendant, also there was no other means to stop the dog. At that time, the defendant was not held liable. Suppose the herd that you are taking, sheep herds, and where the dog has bitten the 2 or 3 sheep, and even the pigs also they bitten. They try to separate with the stick, but still the dog is chasing over there. Finally, the last resort, the shepherd took out the revolver and shot at the dog. At that instance, you can say that yes, the defense of a liable defense is available, because one can protect one's property, one can protect his one goods also. So in this way, we can take the private defense of keeping the own property as well as keeping the own defense of a person. Even to the person, the property, both the cases, we can use the private defense. Yes, if anything that you would like to ask, you can ask me. With this, we will close down our yeah.
Sir, good evening, sir.
Good evening.
Sir,
Yes,
how
now
many,
you can ask
sir,
me anything. Yeah, please.
thank you for the online class, sir. And then how many cases will write on the exam, sir?
See that I told you, I will run the 10 classes for the long questions, and because today I thought of completing the total general defenses, but it's a very lengthy chapter, and hence I could not make it out, even though I'm a bit fast also. But still I completed only the sixth defense, but still the two are defenses are there. Then I will try to complete it tomorrow, and I will start the another set type question. But before I start it, then I will inform you in advance so that you could read and come to the class. Let our class should be a participatory class rather than the sermon class. The same thing that I put it in the WhatsApp group also. You have to read. Come and participate in the class. That will be helpful to you. So these are the which I am taking over there. I already told you that even one student also present over there, I am going to take the classes, because that is my commitment. That is my slogan, where I want to share my knowledge with other people. There, my slogan goes in this way that Anni Danamula Kanna Vidya Danam Minna. And the people, those who